I have a lot of intelligence to mention two connected matters for listing it tomorrow, Your Lordship.
Listing for what?
Listing for motion.
My lord,
They very connected matters. Your Lordship, this is again borderline dealing as judgment, Your Lordship. Judgment which is affirmed by Apex Code on 38/2000.
What is the matter about?
This is a regulation that thing they've been talking about benefits of it. My lord, I beg to mention item number 22, my lord. We have got our relief.
You got your?
Relief. The independence of the content.
Mr. H. Das, counsel for the petitioner submits that the order of this court, order has been complied. Of this court has been complied with, and therefore this contempt case be closed. In view of the submission made by Mr. Das, this contempt case stands closed. Yes.
Made, Lordship. Item 31, my lord, already complied, my lord. Area salary has been paid, my lord.
Mr.
S. Rahman.
S. Rahman, but he may go. 31.
My lord,
Yes,
item 15 of today's list, my lord. I'm
item?
15, 15 of today's list.
Yes.
I'm on behalf of Advocate K. Mira, my lord. This may come after vacation, my lord.
On the
Personally.
prayer line, counsel for the petitioner, admission hearing of this matter stands adjourned, list after vacation.
Item 29, Lordship. Item 29, Lordship. Order,
Yes.
order has been complied, Lordship.
Item 29. Mr. D. Dole,
Lord.
counsel for the petitioner submits that order of this court has been complied with, and therefore the contempt case be closed. Taking note of the submission made by Mr. Dole, this contempt case stands closed.
May I please, your lordship? Lordship, I beg to mention listing of two read petition, lordship, which is recently filed, lordship. There is an urgency, lordship. Lordship, may kindly please take up the matter by tomorrow.
What is the matter about?
Suspension, your honor. For motion.
All right.
A similar prayer, my lord, for motion tomorrow, my lord. We have filed it on first.
Suspension.
Suspension, my lord, and DP is going on, my lord. Now she has got a summon from the trial court on the same subject. The stay of the proceeding, my lord.
You are no longer in the government panel.
No, my lord, I'm for a particular department, not for all.
All right.
I'm always.
My lord, for item 13, we had filed an IA on Tuesday, lordship. The same may be heard together,
Item 13.
lordship.
You want it to be postponed?
We have filed an IA. It can be heard today, lordship, but the IA may be
No,
heard,
I cannot be listed on a mention number. Who's the counsel for the petition applicant?
the governor.
Let him come, then we'll pass it on. You be there.
May I please, your lordship? My lord, I beg to mention item number 30, my lord. 30. My lord,
13, 1, 3.
30, my lord.
30.
May be taken after vacation.
Contempt case, why after vacation?
My lord, this is regarding my lord, pension matter, my lord.
Yes.
I have no death certificate, my lord, and for that death certificate, I have filed a case before the trial court, lower court, my lord.
Mr. F.L. Askel, and counsel for the petitioner submits that the proceeding instituted by the petitioner for obtaining the death certificate is still under process, and therefore this matter will be posted again after the Puja vacation. Prayer allowed, list accordingly.
May I please, your lordship? Lordship, beg to mention listing of a read petition for motion for tomorrow.
What is the matter?
Subject matter is about family pension.
Family pension, why tomorrow after vacation?
Okay, lordship.
Yes, after vacation.
Lordship, similar matter for regularization.
After vacation.
Lordship, pray for listing of a matter, fresh matter tomorrow, my lord.
What is the matter?
My lord, the agency is the petitioner serving as contractual rate for employees under ASDMA. My lord, they are facing financial hardship due to their inadequate monthly remuneration.
After vacation.
My lord,
Not on the
tomorrow-
last day of the year. Rejected after vacation. Yes.
May I please, lordship, I beg to mention item number 36, lordship.
Hmm.
Lordship, lordship, we may allow to withdraw, lordship.
36.
36, lordship.
You want to withdraw read petition?
Lordship, no, lordship, lordship.
Why?
Lordship, there was to be, lordship, some correction, lordship. In the IA.
Your name, please?
I am in, lordship.
Mr. I am in line counsel for the applicant submits that there is some mistake in the IA and therefore he be granted leave to withdraw the same with liberty to file a fresh. Since the prayer is not opposed, same stands allowed. IA number 2613 of 2024 stands disposed of on withdraw with liberty as paid.
Obliged. Lordship, praying for listing after vacation, lordship, 28th. Other matter, similar matter is fixed on 28th. Lordship.
Motion item 1. Please, your lordship, I am appearing on behalf of Mr. S. Your lordship. Lordship, in this matter, Lordship, kindly notice my issue, Lordship, because the petitioner returned on service, Lordship, 31/7/2022, but he's not getting the
appearing for
area
whom?
sellers, Lordship. Respondent, Lordship. Lordship,
Hard
can it
miss.
be passed over?
Hard miss,
J. Bora, Lordship. J. Bora, Lordship.
J. Bora Land Council for the petitioner. Matter pertains to non-payment of retirement benefits and arrear salary claimed by the petitioner. Issue notice returnable in 6 weeks. Miss, your name, please.
Elizabeth.
You are appearing for?
Mr. V. Rajkumar. Mr. V. Rajkumar, standing.
No, I'll record his name, Mr. V. Rajkol, and his standing counsel. Cooperation Department. Assam appears and accepts notice for response numbers 1, 2, and 3, and Mr. P. Nayak. 1 to 4. As such, service of notice. 1 to 4, you are appearing.
Lordship.
1 to 4.
Lordship.
As such, service of notice is deemed to be complete in this case. Extra copyright petition refers to the respondent's case.
Obvious.
Yes,
Appeal has been rejected, Your Lordship.
appeal has been.
Rejected, Your Lordship. Rejected, Lordship. So I have applied him a copy of this.
So you,
Yes.
Mr. P.K. Das, Learned Counsel is present for the petitioner. In terms of the order dated 25/9/2024 passed by this court, Mr. D. Vora, Learned Government Advocate Assam, has obtained instruction and submits that on 2/10/2024, the appeal preferred by the petitioner has been rejected. Obviously, that is because of the query made by the court. This is all fantastic. These appellate provisions should be removed completely.
Your Lordship,
These people are not exercising their power as appellate authorities.
Your
They are
Lordship, what
acting
has
like
happened?
parrots.
What has actually happened? The file had been actually put up late. That's what it is in
Yes,
my
yes.
pairwise
You
comments.
challenge it. You want to withdraw and challenge?
Yes, Lordship, but yeah, yes. Lordship.
That's his main prayer.
This, yeah,
disposal of
this-
that.
You have to take grounds also.
yes, Lordship.
At this stage, Mr. Das, Learned Counsel for the petitioner, seeks leave of this court to withdraw the writ petition with liberty to file afresh after assailing the order dated 2/10/2024 passed by the appellate authority. Prayer allowed, writ petition stands disposed of on withdrawal with liberty as granted.
Obliged, Lordship.
Obliged, Lordship.
May it please your Lordship. Lordship, this petitioner, he applied for a Agniveer musician post. He is a pianist. And Lordship, accordingly, he was given an admit card and he appeared in the examination. But then his candidature was rejected by an excerpt 5 at page 28, Lordship.
We'll have to issue notice at this.
Notice and Lordship, but I have a prayer also,
Hmm.
so that Lordship, at least one post of musician may be
Lordship, that
kept
may be
pending.
considered after the returnable date, Lordship.
Why don't you let her finish? Then you can, yes.
At least one post of musician, because Lordship, we are disputing that he suffered from any disability, because GMCH as well as NEMCare gave certificate that he doesn't suffer from that particular ailment. It's not even an ailment, Lordship. And Lordship, musician is no way connected. So Lordship, at least one post till returnable date, Lordship. One post maybe.
Yes,
Lordship, that may be considered on the
yes,
returnable.
but if you fill up all the posts in the meantime, then we'll
Short
record an
notice,
undertaking
immediately
by
after
you.
vacation.
You will record an undertaking from your side that all posts will not be filled up. Otherwise, an interim order.
Without
There is no third
instruction-
option.
Without
All right, then we'll have
cannot
to
give
pass
you-
the interim order.
Yes,
Third,
Lordship.
Miss R.D. Majumdar, Learned Counsel. You cannot have the cake and eat it too, Mr.
Lordship.
Chakravarti. Learned Counsel for the writ petitioner peruse the amendments made in the writ petition. The petitioner is aggrieved due to rejection of his candidature for appointment in the post of pianist.
Pianist, Agniveer musician in the Air Force, Lordship, Indian Air Force.
In the Air Force,
Indian Air Force.
in the
Indian.
Indian Air Force, on the ground of medical unfitness. Full stop. According to the petitioner's counsel, her client has been declared as medically unfit on a completely preposterous ground without conducting proper medical examination. Full stop. The learned counsel for the petitioner has also prayed for an interim order not to fill up the post of pianist till the disposal of the writ petition. Mr. B. Chakravarti, learned CGC, prays for some time to obtain instruction in the matter. In view of the above, issue notice of motion returnable on 25th of October 2024. Since Mr. Chakravarti has
All the
appeared and
respondent.
accepted notice for all the responding. No formal notice is required to be sent in this case. Extra copies of the read petition requisite in numbers be furnished to the learned CGC. Heard on the prayer of relief, interim relief. This said prayer will be considered in details on the returnable day. However, for ends of justice and balancing equities, it is hereby provided that the post of pianist in question shall not be permanently filled up till the returnable date.
Highly obliged, Lordship.
May I please, your lordship, regarding excess royal melon, the family
It's
pension
not
paper,
already done. It's not already done.
family pension paper all objected, my lord, the excess royal of 2 lakhs, my lord. That annexer E page 18 is the, my lord, impugn
So
order.
tax is TAX, not TEX. Spelling. You read your synopsis.
Oh, my lord, sorry. Yes.
Yes. What is your case, please?
My lord, the annexer E page 18, my lord,
Hmm.
during the lifetime of her husband, my lord, that para 1, my lord, bold type.
So pension is withheld due to excess royal.
Yes, my lord. And my lord, that head of the office, my lord, by annexer G,
All
my
right, we'll
lord,
have to
clarified.
issue notice here. Heard
My lord,
Mr.
Head of
Singh.
the office
What do you
clarified.
want? Final order today?
My lord, it's a
Final order.
lordship.
No. What are you asking for a final order?
No, because my lord, annexer Z is
All right, Mr.
clarified.
Goswami, please take your seat. Heard Mr. C. Goswami, learned counsel for the petition. There is the averments made in the writ petition. The petitioner is aggrieved due to non-payment of pension due and payable on the account of her deceased husband on the alleged ground of excess royal made by her husband during his lifetime. Ms. J. Vora, learned standing counsel.
Lordship, PNR, on behalf of S. Doctor, PNRD Department of Justice. Lordship, respondent number one.
As Dr. Learned standing counsel, PNID Department, Assam prays for some time to obtain instruction in the matter. If you notice, a motion is returnable on 6th of November 2024, since Mr. Datta has appeared and accepted notice on behalf of the respondent numbers 1 and
1,
3.
3 and 5.
Mr. A. Chakravarti, learned G. Assam for respondent number 2, and Mr. P. Nayak, learned SC Finance Department for respondent number 4. Service of notice upon respondent numbers 1 to 4 is deemed to be complete in this case. Extra copy of the petition, requisite in numbers be furnished to the learned departmental council so as to enable them to obtain instruction. Petitioner to take steps for service. Anybody appearing for respondent number 5? You are not even aware.
Lordship,
No.
5.
Huh? Where were you? Watching some movie?
Not shown also.
Who is the government advocate appearing in this case? Chief Executive, are you appearing?
Lordship,
Chakravarti 5 को दो। 2 and 5 को दो।
No, Lordship. There is one side, Lordship.
PNRD, Lordship.
PNRD, as Dr. 1, 3 and 5 को दो, हाँ? बाकी करने का extra copy.
Item 5.
But
Yes.
the 5% compulsion department, my lord, only to.
Compassionate is closed. Shop is closed.
Then,
After vacation.
yes, sir.
On the prayer of Mr. A. Chaudhary, this matter was passed to a list after vacation. No more compassionate appointment. Yes, who is appearing? Pass over to the timing.
Item 7.
Seven. Yes.
The petitioner has approved this honorable court, whereby he was placed under suspension. He is a Gaon Pradhan, my lord. Now, my lord, there was some few litigation before this court, my lord. Being a private, there is a complaint. Initially, complaint was lodged by one Sulemana Khatun, saying that how a mutation has been granted in the name of the petitioner. Then we filed a written objection before the authority concerned. Immediately, a title suit was filed. Title suit was filed by one Saraswat Ashram. They filed a title suit, and in the title suit, they made the complaint as a party and me as a party how mutation was granted. Now, my lord, notice at page 58, if a lordship kindly see at page 58, a notice was issued by one SDO.
So what are you challenging here?
No, we are challenging the suspension order which was passed by the authority at page 81. And that could not have been passed because of page 80. Kindly see page 80 of the High Court's order. See the page 80 operative portion of the order, my lord. Kindly see at para 7, at page 80.
Yes.
In the letter dated Swain District Commissioner Swain, it has been convinced in the petition of being a Gaon Pradhan, but there is necessity to encounter the allegation against the internally before initiation of departmental proceeding. It appears the said letter is the two proceeding initiated against the petitioner. Few other respect allegation made in the complaint submitted by so and so regarding illegal mutation in respect of the aforesaid two plots of land. Two proceedings are not departmental proceeding, and an inquiry is a complaint of same nature. In such view of the matter, the court is of the considered view that it would be expedient for the purpose of consistency and to avoid the possibility of passing of conflicting orders in two different proceedings in respect of the same subject matter. District Commissioner shall get both the complaint inquiry into by an authority, either by himself or by any authority under his superintendence as the case may be, for expedient consideration such proceeding. Petitioner has to ensure participation in said proceeding, and for the purpose, the judicial district commissioner of the authority who will be entrusted to conduct the inquiry shall serve due notice to the petitioner for his appearance. It is therefore directed after taking a decision for consolidation or proceeding, the petitioner should be duly intimated about date of hearing. Now, my lord, let's page 81. Kindly see 81. In view of the inquiry pending so and so under certain immediate effect. Now, this is an order, and
What is wrong?
That doesn't fall under 162A. Kindly see the 162A of the executive instruction. This is a mutation, my lord, which has been in my wife's name.
That is another matter. Whether
Yes.
the authorities had good ground to suspend or not, that is another matter. Why you are challenging this order?
Why I am challenging, my lord? Because if you see at page 80, my lord, page 80, the observation made by the learned single judge is that, and there are not only this proceeding, this is a proceeding is regarding the private dispute where a suit has been filed. Suit was filed, and the complainant who has lost this particular case against me, she was a defendant. I was also a defendant.
All right, so what is the order? you're
What I
saying?
am saying, my lord, it's not that I don't proceed, I will not participate in the inquiry, but they should not have suspend me in this manner, my lord. That's my case, my lord. And
No,
they said,
Mr.
where is the question of the
Mr.
fine?
Das, you are one of the most experienced
No, I will not
stalwarts here. They should not have suspended is not an argument you can make in a court of law. Whether they should or should not have, we
No,
are not
that's
going to go
my lord,
into.
what I am saying.
If
When
the order is without jurisdiction, we'll.
no, kindly see 162A, my lord.
Hmm.
162 of the executive instruction.
What is 162?
162. 162. That's how you remove from the particular post. Before removing of the post,
But
my
this is only order of
no,
suspension.
I know, my lord. The grounds on where it can be removed, kindly look into it, my lord. I know, my lord, suspension is not a punishment. It's only an inquiry. But only on the backdrop of the case, I have come up before this.
Are you available
My
during
limitation.
vacation?
I'm sorry.
You want to appear during vacation? No.
That's I.
Choose a
I
date
don't
after vacation.
I don't want to
We'll ask them
appear.
to obtain
I don't want to appear in vacation.
Even in lordships,
It's a shocking query coming from the court for Mr. Dar.
even in lordship,
One second, your lordship.
No, what I was saying is we have facility of arguments from
I know,
abroad
virtual.
online. That's why. Counsels from abroad can also argue online. That's why we are asking.
Let them produce the record also.
even in lordship 162C, my lord, there is the alternative remedy, my lord. They have to file an appeal before the my lord concern order.
Oh, for it, we have seen what appeals are happening. What appeal? What appeal? Which appeal has been decided in favor of the complainant or the aggrieved person?
No, that
In
provision
a
size.
state has a single appeal under any department been ever decided against the department? We are not going to accept this argument of alternative remedy. We are going to lay down the law very soon. These appeals are nothing, they are acting like mechanical parrots and robots. Every case, the decision is always upholding the departmental. There is no application of mine or what is this appeal all about? In this Gram Pradhan, had a single appeal been decided and decided in favor of the complainant. You know, the appeals don't matter, but only on the ground that without hearing the other, sir, we can't make any comment on the suspension order. But Mr. D. Das, Learned Senior Counsel, assisted by Ms. Learned Counsel, appearing for the petitioner, assailing the order of suspension dated 12/9/2024. This writ petition has been filed internally contending that in view of the observations made by the learned single judge in the order dated
The order is
2024, passed the WPC number 756.
1-3.
Early 2024, the respondent authorities could not have placed the petitioner under suspension. It's not. I think the grounds taken in the writ petition. Mr. J. Hendrick, Learned Standing Counsel, Revenue Department, Assam, and Mr. D. Bora, Learned Government Advocate, Assam, have prayed for some time to obtain instruction in the matter. Where allowed to issue notice of motion. When do you want it, Mr. 23rd? 23rd of October 2024. Since Mr. Hendrick, you are appearing for whom?
Oh, yes, number one, Lordship.
For number 1. And Mr. D. Bora for respond numbers 2 to 4. Service of notice upon the same respondent is deemed to be complete. Extra copies of the writ petition
Okay.
be furnished to the learned department counsel so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon the respond number 5 by registered post within 3 days from today. Or on the prayer of interim delay, the said prayer will be considered on the return of the date. Mr. Hendrick, you see, we have noticed that this has become nothing but an eyewash. This appellate provision. This is only to hoodwink the courts. Okay. The appellate authorities do not apply any independent mind. Sometimes central government will see they do it. The state, nothing. This is just buying some more time, denying relief to the aggrieved person for another 6-8 months. And the stand taken by before the court is there is an appeal pending. And the appeal is invariably decided in favor of the department. What is the point in having such appellate provision? You must talk to your authorities and
We already been discussed regarding that.
otherwise someday observation will come from the court and you will lose all these powers.
That is true, Lordship.
You will lose your powers to exercise appellate. We will not, you do your appeal or you don't do, we will not wait for you.
Well, records is going to be called for. Records?
Alright.
Yes. they will-
On the next date fixed, the departmental council to also produce the relevant records.
Record one.
Then we'll give them a little more time, 28,
28, a bit of difficult, but and 2nd of November or 3rd,
2nd November.
2nd November, dear. 2nd November, let him give him more time. Or 2nd November, I have to come alone, my God. 2nd November, I have to come alone. Maybe on 3rd or 4th, which is 4th is Monday.
Returnable on 4th, yes.
And if he applies. I know suspension is bit of suspension.
No, we understand, but we have to follow the.
Yes, of course, my, of course. Deeply obvious.
Wait, Lordship, I pray for passer for time being.
Time being or 2 weeks.
Time being.
Make me the Lordship. My lord, this is a case where the petitioner service is sought to be taken in. Just arbitrable, what had happened, my lord? She's
She's serving under whom?
under the respondent number 3.
Is it a government organization?
Yes, partly Tata and partly government. My lord, she was appointed as a consultant radiologist in Dibrugarh Cancer Center for 1 year with effect from 1/8/22 to 31/7/23. Then it was extended by another 1 year from 1/8/2023 to 31/7/2024. Thereafter, my lord, there was negotiation going on. Now, for the month of August, she was allowed to work and she was given the remuneration also. Now, what had happened, my lord, though she was appointed as an consultant radiologist, she was also asked to do work as a consultant intervention radiologist. For which, my lord, there was an understanding that she would be paid some more, remuneration. Now, my lord, taking note of all these things, now service has been terminated on the ground that I am insisting on a part of the profit. What is this, my lord? Can you do away with service like this?
So where is the order? Where is the order?
Yes, at page 42. On July 26th, we had a detailed discussion with you on renewal of your engagement contract with ACCF. This is based on the request put up by you for review of your professional fee by email dated so and so. During discussion, we had clearly mentioned that as per the company policy, 6% increase on your current professional fee can only be considered as you had agreed to it. But it has now been brought to our notice that you have requested for profit sharing for a fee of the procedure. Since the practice of profit sharing is not available to the full-time consultant of ACCF, management has decided to exit engagement contract with you and not renew the same. Because I never insisted on any part of the profit. On the contrary, during the course of my lord and online discussion, my lord, what was insisted upon was that you should also pay me for working as an consultant intervention radiologist. And to which they agreed. They said, we'll give you 6% increase. Now, my lord, what had happened? Actually, I am pregnant, my lord. Now, during this period, my lord, I'll be entitled to leave and all. So that is the only reason, my lord, they have done this. And it had transpired during, my lord, the online discussion which took place. My lord, end of the day, you are an authority under Article 12. Can you deal with somebody's right like this?
But the contract is expiring in July 2000, had already expired.
No, my lord, question is not of contract. My lord, end of the day, these are all new things. My lord, our jurisprudence has also to come up to match with these, my lord, new concepts which are coming up. Kindly appreciate, my lord, end of the day, government is engaging somebody. That too, after interview and all, you are making selection. Now, you would like to Christine it is sometimes contractual, sometimes you will say quasi-government. End of the day, you're taking my service. You don't want to pay me my dues. That's why you're using all these terms. But can this be
So what is
permitted?
the relief you want to continue?
No, what, my lord?
You want to continue beyond 31
No, my lord. If they feel that I have done anything wrong, if they want to get rid of me, there is a procedure prescribed. Can you get rid of me like this?
Mr. Chaudhary, we are trying to appreciate your clients.
Yes.
But you will know it more than anybody else.
Yes, sir.
We have to go by the edict of law.
Yes.
Correct. Now, whatever be the consideration, your client was engaged on contractual basis.
Yes.
That contract came to an end on 31/7/2020.
Yes.
They decided not to renew the
No,
contract.
my lord, if they decide not to renew my contract on the ground that there is no work, very well. But on some stigma, my lord, you cannot do that.
So what is the stigma?
Stigma is, my lord, I'm expecting some profit on the booty.
We'll clarify that this will
No,
stand
no,
removed.
it's not a question of clarifying. Where do I go, my lord? No, it's not that they will not engage somebody else. It's not that there is no need of the work. End of the day, lordship, end of the day, my lord, if these aspects are
How
not
can
looked
the
in.
court say that even the contract has expired, she will continue in
No, my
service?
lord, if contract has come to an end, if you want to get rid of me for reasons which is acceptable is very well. But you can't get rid of me on reasons which are not acceptable. How it can be acceptable, my lord? Therefore, my humble submission is, my lord, this order should be stayed. Let them take a call. My lord, at least the principles akin to Article 311 will apply. If not Article 311, akin to 311 will apply. Where have they applied, my lord? Can you get rid of somebody like this merely because you desire, my lord? I am pregnant. They know now I will be entitled to some leave. There are other prayers also there, my lord, under the Maternity Act, which I have made in this writ petition.
Yes, what do you have to say?
She is already terminated, lordship, on 9th September. So contract is already over.
My lord, actually, for the month of August, we have received the salary. For the month August, I was engaged. I was given my salary also. Not that 6%. Otherwise, I have been engaged whole month of August. So, my lord, all that I am trying to seek from your lordship is a simple answer, my lord. Is this the way somebody can get rid of somebody's employment? Because it's an stigmatic order, my lord. I can appreciate. My lord, abolition, creation of post is always executive's prerogative. Tomorrow, if government says we want to abolish this 100 posts, nobody can come to the court and complain. But the manner in which, my lord, I am sought to be get rid of, is it permissible? Is it not that they're
Post is term,
they are
contractual.
founding their actions on some allegation? If you are founding your actions on some allegation, then I am entitled to some protection. That you have not given.
We'll examine it.
Yes.
But Mr. K. M. Chaudhary, and senior counsel, assisted by, who is there? What is your name?
AR Borwa.
Huh?
AR Borwa.
K. R. Borwa, and counsel for the petition. There will be amendments made in the writ petition. The writ petitioner is agreed by the order dated 9/9/2024. Passed by the response number 3.
Why?
Refusing to renew her contractual service as a consultant. Mr. Chaudhary submits that the grounds on which the order dated 9/9/2024 has been issued are not only factually incorrect, but the same also casts a stigma on the petitioner, thus causing serious prejudice to our interests. On such circumstances, the order dated 9/9/2000, in such circumstances, the order dated 9/9/2024 deserves to be interdicted in this proceeding. First of all, Ms. D. Bora, Learner Standing Counsel, Health and Family Welfare Department, while resisting the submissions made on behalf of the petitioner, submits that the contract has already come to an end. No interim order be passed at this stage. She prays for some time to obtain instruction and produce the reports.
I am appearing for 1 and 2, lordship.
1 and 2. Above, when are you available, Mr. After?
And I am available, madam. After the post vacation, I am there.
So we are seriously thinking of having a more robust online system so that councils can address the court even from abroad. 28?
I think so.
28?
Yes.
28/10/2024, since Ms. Bora has appeared in.
I am told, I do not know, that there is a particular expression brought with or banned or something. We say in this part of the country is weak, my lord. Normally what happens
Let
in-
me dictate the order. We'll respond to this. Respond numbers 1 and 2.
Bandwidth,
Such
bandwidth
service
make
of
me
notice
Ah.
on the said respondents is necessary at this stage. Is called for in this case, extra copy of the writ petition will be furnished to the learned department counsel so as to enable to obtain instruction. The petitioner to take steps for service or notice upon respond numbers 3 and 4 by registered post with AD within 3 days from today. Hard on the prayer of interim relief. The said prayer considered on the return of it.
Yes.
Yes, we have recently
Yes.
spent 13 crore rupees to upgrade the entire system of the High Court, including the network, the data service, the LAN, everything. Today, Guwahati High Court can boast of having the best of networks in the country.
Okay.
Insofar as judiciary is concerned. But the problem is, as you said, the network outside the High Court, that is not strong enough. And it has to be a synergy of both the systems.
Otherwise, you don't work.
Otherwise, if you hook on from outside, there is a lag, there is a snag. But this is something we can't do anything about it.
No,
You
recently,
may be
my lord,
right.
I wanted to do a case online from Guwahati in Supreme Court. And our great colleague Manish Goswami said, no, don't do, you come over. Because every time you do things from Guwahati, we're having some problem. They say the bandwidth or something, I don't know, there's a technical term, which is not very effective in this part of the
But
country.
what about the internal system here?
It's good, it's good. It's
We have
working.
upgraded it
Ah.
last month only.
But only thing is now the registry has said that we should give our some phone number or something. And will it be safe if we give those number? Will it not be exposed to, our data and all? I don't know. I'm just posing a question because registry is saying if you want to avail Wi-Fi facilities and all, you have to give. I think
No, that has been done for us also.
okay.
All the judges have to
Okay,
give.
okay.
That is for a systemic reason.
Okay.
But if you think that is an issue, it can be looked into.
I think
can
better.
But without the numbers, you will not be able to hook on. Because some
Model
identity,
number of the phone.
some
Yes.
address is required. Otherwise, people from outside will come in.
Okay.
So these are technical requirements, but
Ah.
if there is an issue, it will be looked into.
Ah,
But without that,
It is
you
not
will not
possible.
get it. So even the judges,
Everybody has shared it. Anyway.
all my
Deeply.
devices which I hook on are, they have the model number.
Deeply.
I'm very pleasantly surprised, but our respected friend, Mr. Chaudhary's technical know-how seems to have improved substantially.
Why are you surprised? It is always been-
And this is a case, my lord, the facts are very long. Considering the pre-vacation rush, I won't trouble your lordships with the entire fact. Just briefly to
So
indicate,
you want a notice only?
no, there's an interim period. What has happened is, I'll be very brief. My lord. This man, he was functioning as joint controller of legal metrology. Since the day he was promoted to this post, he was sought to be victimized. Repeatedly, his juniors were sought to be promoted, bypassing him. Repeatedly, this honorable court granted interim protections. Ultimately, a batch of writ petitions, and this is how unfortunate it is. I will trouble your lordship with this document. If your lordship will kindly turn to page 93.
Yes.
This is where the judgment starts. If your lordship will kindly come to page 98, your lordship will just have a look at the dates. There's a reason I'm showing the dates.
Yes, yes.
Page 98.
Yes.
At the very top of the page, your lordship will just have a look at the dates. And what are the findings your lordship will find at page 101?
Yes.
Para 16, right at the bottom, page 101. On perusal of the records, it was found that though the private respondent number 3, Sri so-and-so, principal secretary so-and-so of the state was not the member of the selection board committee as constituted by the chief secretary of the state for selection to the post of controller of legal metrology, but he managed to participate in the concerned DPCs for the promotional post. Moreover, the record also reveals that the said private respondent number 3 prepared the minutes of the concerned DPC promoting the respondent so-and-so to the post of controller of legal metrology much ahead of the said selection committee meeting held on so-and-so. Said respondent number 3 not only prepared the minutes promoting the respondent number so-and-so, specifically stating that the agenda for the selection board meeting to be held on so-and-so signing the name same as on 26/11/2019 by him. It is also seen that the agenda note was forwarded to the chief secretary of the state on 22/10/2019, fixing the meeting on so-and-so. That was approved by the chief secretary on 22/10/2019 itself, which was subsequently postponed to 26/11. So even before the selection committee met, everything was done in favor of the private respondent. And how the matter was closed was considering the intervening gap, lapse. This writ petition was closed as infructuous. And there is an appeal pending against this. Since there was a repeated intervention by this honorable court, what they managed to do is they thrust upon me a bribery case. When I was not in my office, a packet was left in my office drawer and a trap case followed by a disciplinary proceeding that ended in a penalty matter. We filed a writ petition. There is a stay of that. Thereafter, indirectly, what they did was page 128. Now, once that disciplinary proceeding has also been stayed by this honorable court, in exercise of the provisions as prescribed under FR so-and-so read with Rule 61 of the Assam Services Pension Rules 1969, the period of suspension with effect from 8/7/22 to 31/12/22 in respect of Sachindranath Boiswa, the then so-and-so is hereby treated as on earned leave subject to admissibility. So again, indirectly inflicting a penalty. This we challenge. And the order passed is at the next page. Notice on the interim has been issued for consideration of the interim prayer on the next returnable date. This is not yet listed. And now they do this one, page 132. Effectively, indirectly again seeking to recover the those only that has accumulated in my favor. Page 132 and 133. So I'm sorry, Mal. Page, I'm sorry, these are the communications that I've made. 136. And this order that notice on interim has been issued was duly communicated. Now they say that I am to certify that unutilized earned leave for 123 days was at credit to Sri Sachindranath Boissa, so and so, on the date of his retirement on so and so. And next page, I am to authorize you to draw the arrear pay and allowances in respect of Sachindranath Boissa, retired so and so, after adjustment of pay and allowances already drawn by the officer. The authority may be treated as per specified one, and the expenditure is debitable to the head from which, etc. etc. Basically, my lord, the issue on which notice on interim has been issued, they are now indirectly seeking to recover it from my pension benefits. So what I am praying at this stage is, your lordship will tag this along with the other writ petition and fix a date so that the interim can be considered on in the other writ petition, and also maybe this one, both can be considered together. And till then, let them not recover anything.
Your lordship, in that petition, it was subject to outcome.
No,
But where is the recovery? There is no order of recovery.
What they are saying is effectively that you pay him leaving out this balance, indirectly seeking to recover. If your lordship reads 136 and 137 together, that is the meaning that comes out.
All right, we'll consider it as interim
Both,
the next day.
till then, let them not recover anything.
There is no question of recovering. It's a question of,
So,
so if there is any shortfall and if they do anything, we will pass an order accordingly.
and your lordship will fix a date. Otherwise, well, they will continue harassing you.
Which date suits you? Can we fix it somewhere around
On
13th of November?
23rd,
13th of November?
that might be a little too long. 6th, if it is.
All right, 6th. Yes, you are appearing for whom, Mr. Bora?
For respondent numbers 1 to 4.
1, 2?
1, 2, 4. 1, 2, 3, 4.
There are only 4 respondents here.
5 is finance, 6 is accountant general,
All right.
6 and 7 accountant AG can.
Heard Mr. I. Chaudhary, Learned Senior Counsel, Mr.
He does.
Does Learned Counsel appearing for the writ petition? Peruse the amendments made in the writ petition. This writ petition has been distributed internally being agreed by the communication dated 27/8/2024 issued by the senior accounts officer of the Office of Principal Accountant General (ANE) Assam, addressed to the Joint Control of Legal Metrology (Standard Lab) laws, Ulubari, Guwahati, providing for release of pay and allowance of the petitioner after making adjustments of the allowance already drawn by him. First up, expressing apprehension that Mr. Chaudhary submits that the process initiated by the departmental authorities is per se illegal and is the subject matter of dispute in WPC number 3008 of 2024, which is pending disposal before this court. First up, Mr. Chaudhary also submits that his client entertains a reasonable apprehension that in the garb of the order dated 27/8/2024, an attempt would be made to recover amount which is legitimately due and payable to the petitioner. In such circumstances, the petitioner's counsel has prayed for an interim order. Mr. D. Bora, Learned Government Advocate Assam, appearing for the respondent numbers 1 to 4, and Mr. A. Chalia, Learned Standing Counsel, Finance Department, Assam, appearing for the respondent number 5, has prayed for some time to obtain instruction in the matter. In view of the above, the notice of motion returnable on 6th of November 2024, since the Learned Government Advocate Assam has accepted notice for respondent numbers 1 to 5, Mr. A. Chalia for respondent number 1 to 4, Mr. A. Chalia for respondent number 5, and Mr. B. Chakravarti, Learned CGC for respondent number 6 and 7. Service of notice is deemed to be complete. In this case, extra copy of the petition requisited numbers be furnished to the Learned Department Council so as to enable them to obtain instruction. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. Um, It is however made clear that any action taken in the matter adverse to the interest of the petitioner during the pendency of the writ petition shall be subject to further orders that may be passed in this proceeding. Registered to list this case again along with WPC number 3008 of 2024.
Let it come up with the other one.
Yes.
There are two repetitions. One is 300824 and other one is 1907 of 24.
1907 of
24.
All right.
number.
Item 11.
May I please, Lordship? Lordship, petitioner husband is a regular Safai Karmi in Assam Police, Lordship, in 8 APBN. Lordship, sometime in 2004, Lordship, her petitioner's husband was found missing. And Lordship, after he came back in 2012, and Lordship, after long treatment in 2016, he died, and accordingly informed the department also, Lordship. But suddenly, Lordship, the department has issued a certificate in 2019 saying that his service has been dismissed. No so-called, no dismissal order. Only a certificate has been issued that Lordship will find a page.
This has to be examined.
Lordship,
Let them file a
not,
petition.
not.
Heard Mr.
SK Sinha.
Sinha, learned counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by the treatment meted out by the authorities to her deceased husband, leading to denial of retirement benefits. Mr. C.S. Hazarika, learned government advocate Assam, prays for some time to obtain instruction in the matter. NOM 8 weeks since Mr. Hazarika has appeared and accepted notice for numbers 1 to 4 and Miss
Tinlung on behalf of RK Tabular, on 5. Tinlung, TINLUNC.
for respond number 5, service of notice is complete in this case, extra copies, etc.
Well, matter pertains to non-payment of family pension. Non-payment of family
Heard
pension.
Mr. S. Hawk, learned counsel for the petitioner, the matter pertains to non-payment of family pension. Issue notice, the motion returnable in 8 weeks. Mr. S. S. Roy, learned CGC appears in
1, 2, and 3.
notice on behalf of respond numbers 1, 2, and 3. Why not 4?
S. Yasmin Lordship, 4 and 5.
And Mr.
Miss S. Yasmin. For
S.
on the
Yasmin,
4 and 5.
you are standing counsel. Then
On behalf of M.
who is this standing counsel here?
Sharma Lordship.
Then we'll write his name and Mr. M. K. Sharma and his standing counsel, Central Bank of India. For the respond numbers 4 and 5, hence service of notice is deemed to be complete in this extra copies, etc.
I am obliged.
Supplementary list for motion item 38.
That suspension matter, Malad.
What is it matter?
Malad, the petitioner was placed on the deemed suspension, Malad, which effect from 30/12/2023, Malad. Since then, Malad, no DP, no review.
Where is Mr. Henry? Just wait,
Malad.
take it over to some time.
Please, Your Lordship. This is a case of compulsory retirement, my lord. Can you see the impugn order at page 69?
At page
69, my lord. 69. 69. This is the order, it is issued, dated, it was 17 September 2014. But the petitioner, my lord, he was serving up to 20th, 20. But this order, it was issued on back date, my lord. The 17th September 2014.
24. Here it is said. Whereas the appointing authority is of the opinion that it is in the public interest to do so. Now, therefore, in exercise of the powers conferred by Clause J of Rule 56 of the Fundamental Rules, the competent authority hereby retires Dr. Dhrubajyoti Setia, Associate Professor, Psychiatry, with immediate effect from the afternoon of 17/9/2024 on completing 55 years of age. Dr. Setia will be paid a sum equivalent to this amount of his pay and allowances for a period of 3 months calculated at the same rate at which he was supposed to be drawing them immediately before the retirement. However, the Setia reserves the right to submit representation against this order to the Seven Executive Council. My lord, I was first given protection by this honorable court in 50. 50 to 50. Annexer? Yes. Annexer 50, my lord, page number, the relevant portion, it is at page 52, my lord. Here, in the meantime, it is directed that no coercive action shall be taken against the petitioner pursuant to the communication dated 28/2/2024.
So what is the case about? What is your case?
Case, my lord, that 56J, Fundamental Rule 56J.
Well,
Under that
we'll
provision,
examine the matter after vacation. What is your case?
my lord,
52nd, 58, forget it.
Yes.
What is your case?
my case, my lord, this rule is not applicable in my case first.
Hmm.
As because
Who is appearing for the you are appearing
I'm
for
appearing for respondent number, the 4 million, the director.
for number 4.
Yes.
It's a private individual.
Yes, I'm the director of that LGBI Institute of Taste Food Mill.
It's all right, but this is an order of retirement.
It's not a case of compulsory retirement. Compulsory retirement has its own legal connotation. It's a case of premature retirement on assessment of the service profile invoking FR 56J. It does not entail any inquiry mill. The law is well settled. So at best,
What is
Lordship will
the age
examine
of-
this matter.
What is the age of retirement?
Age of retirement is 60 years.
no,
No,
65 is a
65,
faculty.
65. But here, my lord, to invoke FR 55, 55 years is enough. That's the prescription.
No, but who can invoke it?
The appointing authority.
Who is the appointing authority?
Appointing authority is respondent number 4.
Who is appearing for the department?
It is a mandatory requirement of the government. Each department requires to review the periodic review of the employees. As per the office memorandum.
You are appearing for whom?
I am for the institute, madam. LGB.
What is the respondent number?
Lukopio Gopinath Bordole region.
Acha, you move out. Yes, you are appearing for whom?
Actually, I am for Resolution 1 and 2, Lordship.
1 and 2.
1 and 2. Here, Lordship, the
And
implement.
you are, Mr. Datta, you are for whom? 1 and 2.
Institute.
Respondent numbers.
Phone number 3, madam.
You are not for 3.
I am for 1 and 2, Lordship.
Ah.
1 and 2.
So what has happened? What is the
Lordship,
matter?
here, page number 69, my lord may kindly peruse, Lordship.
First, tell us what is the matter. With no perusal.
Lordship,
What is
Lordship.
the story?
The issue is that, Lordship, the particular Lordship petitioner was, Lordship, he was given the compulsory retirement, Lordship, on the basis of the rule, Lordship, 56J, Lordship. Otherwise, Lordship, the person who have passed the order, Lordship, as on that he is not holding the post of the director, Lordship.
That's not material.
Lordship.
What is his authority to pass this order?
Regarding, at present, Lord, he has no authority, Lordship. From Lordship, August First
When
pro-
he passed the order, what was his authority?
17.
At present, how does it?
Lordship, on 17/9, he is no more the director of the institute, Lordship. In 17/9, he has passed the order, Lordship.
Where do you say so?
Lordship.
Is there any order?
Why different? Different.
Lordship, this order was passed despite having protection order from this honorable court. There was a stay regarding this order, Lordship. 56J was initially communicated to the person, and that was challenged before this court. There was a stay saying that no coercive action may be taken till the final disposal, Lordship.
Where is that order?
Lordship, may peruse page number 50, annexure 11, Lordship. The relevant portion it has page number 52, wherein it is said,
Yes.
it is said that in the meantime, it is directed that no coercive action shall be taken against the petitioner pursuant to the communication dated 28/2/2024. Lordship, this communication was regarding this. It's the same letter. The director attempted to compulsorily retire this petitioner even before this time.
It's 60.
And that communication, Lordship, 28/2/2024 read, in reference to the subject cited above, I am directed to inform you that as per recent government directives.
Where is that?
Lordship, we have challenged it in another writ petition, that is 1402.
In this petition, where is that order?
Lordship, that order has not been annexed. However, the stay order has been annexed, Lordship. That was the earlier communication, which we challenged before this court. It was stayed, Lordship. After that, he again passed this order. And we were removed.
What is this order 28/2/2024?
That is what, Lordship, I was reading. Lordship, may kindly.
Yes.
No, what is this? This order is of 19 September.
19 September, Lordship.
And the order impugned is of 17 September.
Lordship.
Then why? How?
No, Lordship, the persons concerned with effect from 1st of August, Lordship, he is not in the office. Lordship. He is retired in the Lordship 31st of July, Lordship, after attaining the age of 65 years, Lordship. We have, Lordship, the ad hoc arrangement summons is given, Lordship, to the in-charge director, Lordship.
Are you supporting the order impugned in this writ petition?
No, Lordship, I am not supporting. Yes, because he is not the authority, Lordship, at the relevant point of time. He is not the authority to pass the order, Lordship.
And what about you?
The institute has not received any information from the ministry.
He, after attaining the age of 65 years, Lordship.
Position, my lord,
65
because
years.
everybody is in hand in gloves, my lord. Let me explain the position. Sangu sir. My lord, will kindly note, on 22/7/24, an order was passed by the Government of India, Ministry of Health and Family Welfare, that respondent number 4 will retire on 31st of July on attaining the age of 65 years. Normally, yes. Now, what had happened, my lord? Against that, we preferred, the respondent number 4 preferred a writ petition. And the writ petition, in the writ petition, an order was passed, which your lordships will get at page number 6. Page number 6 of this compilation. Please come to page number 9, my lord. Para 7. Taking into account the facts and circumstances recorded above, a case for passing of an interim order is made out. Accordingly, it is directed that impugn order dated 22/7/24 pertaining to superannuation of petitioner is concerned is still stayed till the next date of hearing. Subsequently, it is extended, my lord. It is, however, clarified that aforesaid stay order is only pertaining to service of the petitioner and not confined to the post of director. In fact, my lord, and a submission was sought to be made on behalf of the Government of India that as far as the post of director is concerned, this stay order should not cover. But this is the order. The order is the order of 22/7/24, whereby the respondent number 4 was sought to retire on 31/7/24 has been stayed. And the Honorable Court also clarified that this will also include the post of director.
No, but Mr. Chaudhary,
Yes.
today you are representing the
I'm
respondent
on respondent number 4.
private capacity. In
Of
his
course, my
private
lord, they have made me party. Lord,
So,
no,
Mr.
no, one
Gogoi
more
says-
thing, my lord, one more thing. Then, my lord, what had happened? He was, now what had happened on 17/9/2024, it appears the petitioner in this case was prematurely retired. Now, on 19/9, an order was passed whereby somebody else was sought to be given the charge of the director. That has also been put to challenge in this honorable court in a writ petition, I think 5054 of 24. Yesterday, my lord, the matter was heard. Now all the matters have been fixed on post vacation. And in the earlier case, my lord, that is where I was sought to be retired. That matter has been heard and it has been reserved for judgment. Now the question is, apart from the fact that here in this case, one more point has been raised, that I have been removed by a person. Sorry, the order of premature retirement has been passed by respondent number 4, who is not even director. That is not correct. In any case, on 19/9, 2 days thereafter, an order was passed whereby a temporary charge was sought to be given. Lordship knows a temporary charge can be given when the post is vacant. So there is no question of I not being serving, my lord. Now the government of India has not taken this decision, my lord. This appointment committee on cabinet has to take the call. They have not taken the call. It is the minister who has done it. A lot of things are there in this case. It can't be taken, a particular view cannot be taken in this matter.
Lordship,
like
however, may kindly take into consideration the stay orders that were there, Lordship. Lordship may kindly see annexure number 10, Lordship.
Come this side.
Lordship.
Yes. What do you want to show?
Lordship, I want to show that there are certain stay orders, Lordship, from this honorable court not to take any coercive action. Despite that, this action was taken. Lordship, that is what I want to, that is the point I want to put forth, Lordship. Lordship, may kindly peruse annexure 10, page number 47, wherein the disciplinary proceeding against the petitioner was stayed, Lordship. The relevant portion is page number 49, Lordship.
Mr. Chaudhary will examine this matter.
No, Lordship will examine. I am not saying Lordship
We'll
will not
stay this order.
No, Lord will kindly come to one second, my lord. Disciplinary proceeding is on its own merit. But when it comes to invoking FR 56A, there's nothing like it. Well, I brought the Supreme Court.
Lordship, this could not have been invoked. Lordship, may kindly peruse page number 58, Lordship.
No, I'll just hand over one copy, my lord. One paragraph.
No, but there is a personal rivalry. Otherwise, individually.
There is no,
why-
my lord, personal rivalry against me.
No, but why are you individually?
Lordship, I am a directorial
Well,
candidate
when
as well.
sought
There,
to
there
be
is a
dragged in, why
rivalry,
should I
Lordship.
not?
Take your seat. Otherwise,
My
I'll
lord,
postpone the matter. after
when
the
I am
petition.
sought to be dragged in, my lord, whole bunch of people, state government, government of India, everybody is against me, my lord. Now, my learned friend is appearing on behalf of respondent number 1 and 2 and the submission he is making. Somebody is sitting on the left-hand side, somebody is on the right-hand side. Well, I have been cornered from.
But how
all
are you
angles.
interested that he should continue?
I'm interested because I'm holding that post. That's all. Well, please have the judgment for him in one paragraph. Now, they are saying there are stay order of the High Court that is on the disciplinary proceeding, not on FR 56A. Now, please come to para 9. Now, coming to the express words of Fundamental Rule 56A, it says that appropriate authority has the absolute right to retire a government servant if it is of the opinion that it is in public interest to do so. The right conferred on the appropriate authority is an absolute one. That power can be exercised subject to condition mentioned in the rule, one of which is that concerned authority must be of the opinion that it is in public interest to do so. If that authority bona fide forms that opinion, the correctness of the opinion cannot be challenged before court. It is open to the aggrieved party to contend that the requisite opinion has not been formed or decision is based on a collateral ground or that it is an arbitrary decision. The first respondent challenged the opinion formed by the government on ground of malafide, but that ground has failed. High Court did not accept that plea. Same was not presented before us. The impugn order was not attacked on the ground that required opinion was not formed or that opinion formed was an arbitrary one. One of the conditions of the first respondent service is that Government can choose to retire him at any time after he completes 55 years if he thinks that it is in public interest to do so by him before retirement. Compulsory retirement involves no civil consequences. The aforementioned Rule 56 is not intended for taking any penal action against any government servant. That rule merely embodies one of the facets of pleasure doctrine embodied in section Article 310. So, my lord, now the petitioner side, they are relying on, my lord, that. So, Mukitapun give. Mukitapun give. Please have a look at 56, my lord. It has got nothing to do with any penal consequence. It is akin to the pleasure doctrine as in, my lord, Article 310. Except as otherwise provided in this rule, every government servant shall retire from service. Sorry, J. Notwithstanding anything contained in this rule, appropriate authority shall, if it is of the opinion that it is in public interest to do, have absolute right to retire any government servant by giving him notice of not less than 3 months in writing or 3 months pay of allowance in lieu of the notice.
So
Lord, Lordship will examine this matter,
just
that
a
I'm not
minute.
saying, but
Who is the appropriate authority here? Who is
To-
the appropriate authority for FR 56J? Who is the appropriate authority for FR 56J?
appropriate, the appointing authority. Appointing authority is the director.
Is it so?
Yes.
Where is the order of appointment? Is it a part of the record?
Yes.
Where is it?
Appointment order, whether they have annexed it.
That's actually.
Appointment order. Yes, appointment order later issued by, it is there, my lord, 18/8/2011.
Annexure 3.
Page?
28, Lordship.
Yes. No, you do not. Appointment order report. Yes, it is with the director, my lord.
Can't be the director. It has to be the government.
All appointments should be noted for the Ministry of Health and Family Welfare, Government of India also, not the director. Even director was appointed by the government of India.
I am not being able to hear your voice now. Answer this question.
Lordship.
Oh, again,
Mali,
who is the appointing appropriate authority here?
yeah, my lord.
If your lordship would kindly come to page 33, my lord.
No, this is promotion.
Yes, promotion, this is the SK Deori director.
The promotion I can give. Mr. Chaudhary, you know, don't get into that area. Promotion and appointment are two different things.
Yes.
No, appointment order, my lord, they have not annexed, but appointing
Yes.
authority. Appointment order to descend.
This-
Page 28 is not an appointment order, my lord. They are conveying the approval.
It is approved by the government, and this is kindly see, my lord, from page 35, my lord, annexure 3. And this is the appointment order. It was.
My lord, page 30 is the appointment order. It is issued by the director. Page 32 is the director's signature. Page 30. Offer of appointment.
Final leave to defer দিব final leave to defer দিব final leave ল'বলৈ কোৱা আছে already.
So nobody is prepared to operate instruction.
No one.
See, in respect of Uttar Director, see, there is no stay order from the honorable courts from 1st of August 2024, he is no more director. whether this order is.
Very
on the-
disappointing. Nobody, you don't have any instruction. You don't know who's the appropriate authority, nothing. So we'll post it again on reopening date
Yes,
by giving liberty to the appropriate authority to review the order in the meantime. If so.
yes.
But Mr.
My lord,
So,
my lord, I want to
yes,
comment
yes.
on one point.
Mhm.
Kindly give me, my lord, one court's order at page 60, my lord. Page 60, 60. The relevant portion, my lord. In IA, I have filed in that IA, the order was passed. my lord. The last parameter, last two parameters.
All right.
In any case, before taking a final decision, the respondents either have to take a leave from this court or some orders is required to be passed in the writ petition, in absence of which no final order can be passed. So in spite of this order, my lord, he has passed the final order. And that too,
All right, I heard Mr. K.K. Fukun, learned counsel for the writ petitioner, assailing the order dated 17/9/2024, issued by the respondent number. You have not even implicated the director, the party here.
yes, it is completed.
Director
By
is,
name goes.
huh?
By name has been done.
No, this is
By the director of Lokopriya Gopinath Bordoloi Regional Institute of Mental Health, bracket LGBRIMH, bracket close, Tezpur. The instant compulsorily retiring the petitioner on attaining the age of 55 years with effect from the afternoon of 17/9/2024 by invoking clause small j of Rule 56 of the Fundamental Rules, bracket FR, bracket close. The instant writ petition has been filed, inter alia contending that the impugned order dated 17/9/2024 is punitive in nature and has been issued in violation of the directions contained in order dated 13/3/2024 and 31/7/2024, passed by the learned single judge in WPC number 1402/2024 and WPC number 3798 of 2024, respectively. First of, it is also the contention of the petitioner's counsel that on the date on which the order dated 17/9/2024 was passed, the respondent number 4 was not even holding the post of director and therefore did not have any authority or jurisdiction under the law to pass such an order. First of all, the said submission of the petitioner's counsel has been supported by Mr. K. Gogoi, learned CGC. You are appearing as CGC, appearing for the respondent numbers 1 and 2, who submits that the impugned order has been issued by the director unauthorizedly and without following the due process of law. It is also the stand of Mr. Gogoi that the respondent number 4 was not holding the post of director with effect from 1st August 2024. Mr. A.K. Datta, learned counsel for the respondent number 3, submits that he has not received any instruction from the ministry. Mr. K.N. Chaudhary, learned senior counsel, edited by Ms. R. Das, R. Kakoti, submits that the impugned order does not suffer from any infirmity meriting interference by this court. After hearing the learned counsel for the parties, it appears that there is substantial confusion as to whether the respondent number 4, who was holding the post of director of LGBRIMH Tezpur, was actually holding the office on the date on which the order dated 17/9/2024 was issued. Full stop. There is also nothing to show that the order dated 17/9/2024 was issued after obtaining the approval of the government in the Ministry of Health Affairs. Full stop. Under the circumstances, if the impugn order dated 17/9/2024 is allowed to hold the field, then in that event, the same may cause serious prejudice to the petitioner, more so since the normal age of retirement from service of the employees of LGBRIMH under the rules is 65 years. In view of the above, issue notice returnable on 23/10/2024. Since the respondents numbers 1 to 4 are already represented by their respective councils, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental council within 3 days from today, so as to enable them to obtain instruction in the matter. So your petitioner is out of service now?
Yes.
Yes. You review the order, we'll give you the liberty. Hard on the prayer of interim relief, this said prayer will be considered on the returnable date. However, having regard to the peculiar facts and circumstances of the case, the respondent numbers 1, 2, and 3 are granted liberty to review the order, to suitably review the impugn order dated 17/9/2024
If so advised, madam.
during the pendency of the writ petition, if so advised, and pass appropriate order therein in accordance with law. First of, any order passed during the pendency of the writ petition shall be brought on record by filing affidavit.
And will be subject to further order of this honorable.
Affidavit, which will be subject to further order that will be passed in this case. Deeply.
But no, this against dismissal of service. The DP was instituted, charges was should, and I was asked to submit the reply. I have submitted my reply, and thereafter no proceeding in fact has taken place. The different officers calling some of the witnesses to his chamber for a hearing, and thereafter the order of dismissal has been filed. It's a gross violation of the Rule 9 of the Assembly Disciplinary.
So notice will be issued at this lodge. By Mr. P.J. Selkan and senior counsel, assisted by Mr. P. Borderwell and counsel for the petitioner, assailing the order of dismissal from service dated is it 5/7/2024? As well as the order dated 16/3/2000. How can appellate authority be later?
Lordship, initially on 10/1 they have passed the dismissal order. I have preferred an appeal.
10/1 or 17/1?
First one is of 10/1. Then on 16/3 I
Order
have
of
preferred.
dismissal from service as well as the subsequent order dated 16/3/2024 passed by the appellate authority, rejecting the appeal preferred by the petitioner. The instant writ petition has been filed, inter alia containing that the impugn order suffers from serious irregularities meriting interference by this court. Mr. J. Handling, learned counsel for the standing counsel for the Revenue Department, Assam, prays for some time to obtain instruction in the matter. Issue notice returnable in 6 weeks. Since Mr. Handling has appeared and accepted notice.
1, 2, and 3.
1, 2, and 3, and Mr. A. Chakravarti, learned government advocate, Assam.
4, 5, and 6.
4, 5, and 6. Service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers be furnished to the learned department council so as to enable them to obtain it.
In this case, your lordship, we have put to challenge the order of transferring the petitioner from district establishment of your lordship Nalbari to South Salmora. And on the ground, he is a grade 3 employee, your lordship. On the ground that they are under their own guideline, your lordship, this transfer could not have been issued. And the reason why, your lordship, that ultimately, your lordship, the seniority of these.
Where is that guideline?
Your lordship will kindly come to page 22. Annexure 5, your lordship. Second paragraph, your lordship.
Page 24.
22, your lordship. Annexure 5. In maintaining such procedure, this is about the inter-se seniority list of LDAs, your lordship. In maintaining such procedure, LDA, UDN of different offices working in the different districts are facing very much difficulties. Being a low-paid employee, they are not able to shift their places of posting or promotion to a very distant places, for which divisions are facing very much great difficulty. As a result, the department is facing some court cases due to such transfer. Further, per procedure, fill up post of so and so, physically handicapped. The government always insists on district-wise data, not as a whole for Assam, also for compassionate ground that are necessary district. To avoid such situation, it feels that the inter-se seniority of LDA, UDN, head assistant should be as per establishment strength of each officers. Accordingly, all offices of district offices may be requested to maintain inter-se seniority office-wise like division circular, etc. below mentioned procedure. Now onward, inter-se seniority of LDA, UDA head assistant should be maintained zone-wise up to 31/12/2007. From 1/1/2008, all inter-se seniority list of LDA, UDA and head assistant should be maintained division-wise and circle office-wise. Then 3, and then 4, your lordship, important. On completion of all such transfer, no any transfer will be allowed on promotion or any cause.
What is the meaning of this, number 4?
This is your 4, your lordship.
On completion of all such transfer means?
That your lordship, the prior to this, your lordship, that since your lordship, the day where your lordship, the seniority list was prepared district-wise, your lordship. So after that, your lordship, all were brought in, your lordship, in the district-wise, your lordship. Then seniority list was prepared, your lordship. Thereafter,
No, Mr. Bothakur, you are saying your client cannot be transferred to another district.
no, within another district, your lordship. There are 2 reasons, your lordship.
He cannot be transferred.
Lordship.
Why?
That is
Because of this?
Yes, your lordship.
No, that.
Then secondly, your lordship will kindly see why this is, your lordship. The seniority list of the grade 3 employees, your lordship. This is, your lordship, on the basis of district establishment. Now, the moment
Please understand the case.
Lordship.
Please understand what is your case.
Lordship.
It will help you argue better.
Lordship.
Seniority list is one thing, and the rules prohibiting inter-district transfer is another thing.
Lordship.
You cannot harp on this to get a result here.
Lordship.
Then we'll stay the promotion, but transfer will go on.
Lordship will kindly.
That is the order.
No,
will
your
pass.
lordship, this why I am submitting
If
this.
you want to get a stay of the transfer,
Lordship.
show us the provision of the rules which debars that. Otherwise, no question of stay.
No, your lordship will kindly see how I will be prejudicially affected by this.
Promotion. Stay the promotion.
No, there is no question of promotion, your lordship. What has happened here, your lordship? The moment I am transferred to another district, your lordship, what will happen, your lordship? I will lose my seniority, your lordship, in the new
Say
district.
that you will not lose his seniority.
Number 1, your lordship. Number 2, your lordship, I was transferred, your lordship, against the vacancy, your lordship. No one is brought in against me, your lordship. That is that, and that is why, your lordship, I am alleging Malefidi that, your lordship, so that, your lordship, I am not going to be promoted, your lordship. That's why, your lordship, I was transferred, your lordship. That's my case, your lordship, and that's why, your lordship, I am challenging this transfer order, your lordship. Ultimately, this notification, your lordship, at page 22, your lordship, this notification is based on that particular rule, your lordship, which says that district-wise seniority will have to be maintained.
Protect your seniority. Protect your seniority.
No, your lordship, if your lordship, but the rule says that it is district-wise, your lordship, the seniority.
Yes, well, protect your seniority in the district.
But the once I am, your lordship.
That you have to show that you cannot be transferred. I am asking you again and again.
That's why, your lordship, this.
No, the seniority list in the district doesn't mean you cannot be transferred.
No,
That
I
is
can
in
be
the
transferred,
government.
but
Yes.
not, your lordship, within the district. That's what I am submitting.
Where is that rule?
Your lordship will kindly come to page 23 again.
Yes, is inter-district transfer permissible?
Lordship, after his transfer order, he submitted a representative before the minister, your lordship. Thereby, the minister has directed the chief engineer to modify the transfer order, lordship. I have the receipt of this copy, your lordship.
That, your lordship, I have no instruction on that, your lordship, because still no order has been passed, your lordship. And
down below its lordship, it's given as modify the order South Salmara to Borpeta.
Borpeta? Okay. Borpeta is fine.
Lordship, so far as your lordship, that if that order passes, but they pass that order, your lordship.
Now,
Still, your lordship, no order has been
now
passed.
the
your lordship.
chief engineer, as per verbal instruction, has said that there is no vacancy in Borpeta, so he might be transferred to Rongya also, Your Lordship. Either Borpeta or Rongya.
Let them pass that order, your lordship, if necessary, your lordship, if that.
Right, I heard Mr. S. Bhattakul and counsel for the writ petitioner, also heard Mr. R. R. Gogoi, learned standing counsel, PhD Department, Assam, appearing for the respondents, assailing the transfer order dated, which page?
Your lordship, that is your lordship. Your lordship will get. Page 22, your 21, your lordship.
Transfer order dated 16/9/2024, by means of which the writ petitioner, who is working as
Senior assistant, your lordship,
Senior
and head
assistant.
assistant in charge.
posted in the establishment of executive engineer bracket PHE bracket close Nalbari division has been transferred and posted in the same capacity in the office of executive engineer bracket PHE bracket close South Salmara, Malkachar division has been put under challenge, inter alia contending that as per the departmental rules and guidelines, the inter-se seniority of the employees in the rank of UDA, LDA, UDA, senior assistants are to be maintained district-wise. Thereby clearly indicating that inter-district transfer of these employees would be impermissible under the law. Notwithstanding the same, and with the sole object of depriving the petitioner of his seniority position at Nalbari, the impugned order has been passed. Mr. Bhattakul prays for stay of the order by contending that same is contrary to the statutory provisions as well as the guidelines applicable to the department. Mr. R. R. Gogoi, learned standing counsel, PhD Department, Assam, submits that acting on the representation dated 29/2024, submitted by the petitioner before the departmental minister, instruction has been issued to the chief engineer PHE to modify the transfer order of the petitioner from South Salmara to Borpeta. However, if vacancy is not available at Borpeta, then the petitioner may be posted at Rangia. First of all, the petitioner's counsel is agreeable to a posting at Rangia.
Lordship, if they passes your lordship, without taking instruction, it will be difficult for me to say. But if they passes your lord, let them pass your lordship.
Since such developments have taken place in the meantime, I am of the opinion that the matter would call for further examination. As such, issue notice of motion returnable on 22/10/2024. Since Mr. Gogoi has appeared and accepted notice on behalf of
All the respondents, Lordship.
all the respondents, as such, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the learned department counsel. So as to enable him to obtain instruction. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that status quo as regards the transfer of the petitioner to South Salmara division is hereby suspended. However, pendency of this writ petition shall not be a bar for the authorities to modify the transfer
Yes.
order as per the instruction issued by the departmental minister. If any such modified transfer order is issued, it will be open for the
Yes.
petitioner either to accept
Loss.
it and join accordingly or to assail the same
Yes.
in appropriate proceeding. This the matter accordingly.
Wait, please, Lordship. I am sealing the order of transfer dated, my lord, 26/7/2024, my lord, with peculiar condition attached thereto. I am coming to that. The petitioner was, my lord, since his appointment 2004, was posted in the hard season in Arunachal Pradesh, my lord, and he was also getting the hard season allowance, sir. Now, my lord, then he was transferred to Shillong to Guwahati. and Brahmaputra Basin Organization. He is now in Guwahati since 2019, 21/10/2019. Now, my lord, his child is a sort of, I don't know, the undergrowth or the non-growth at all. Now he is 2 years, 6 months, but size is same. So on that ground, my lord, he sought some modification in the transfer order and representative file. And ultimately, there is also my lord, circular dated 8/10/2018 is regarding
Where is the representation?
representation is on page 36. That is, I have narrated the entire case, my lord.
No, this is before the transfer order was passed. Where is
Yes.
the impugned transfer order?
Impugned transfer order is my lord, page 29, sorry, page 43.
Page 43.
Yes.
This is a series transfer.
Series transfer, my lord, but your lordship will kindly come to page 44. Last but one, my lord, the Zakir Hussain, in his place I am transferred. You will kindly come. Posted in their present place till.
You submit a representation within 3 days. We will consider it.
No, man, just let me read that one. The person who is posted here will remain in Delhi till 31/3/2025, but he will enjoy the salary from here, from the post.
We are this none of our business.
My lord?
We'll not get involved in all this. You can submit, but nothing will be recorded on that. These are different matter. You are challenging your transfer.
Yes.
Transfer, the scope is very limited, you know.
Limited, but
These difficulties you expressed before the authority.
I have already expressed my difficulty.
But that is before the transfer.
Yes.
After the transfer, you have not.
Yes.
Then you file a representation. Who is the authority to consider it? Mr. Gupta?
Well, it is respondent number 3, man. Chief Engineer, Brahmaputra Basin Organization.
How can he be?
No, it should be Ministry
Nobody
of
looks up
Number
the
2.
papers, huh? You have not even made that person a party.
No, it is the respondent 1 and 2, my lord.
Yes, 1. All right. But Mr. R.P. Sharma, Learned Senior Counsel, instead by Miss. What is the name? K. Dekal, Learned Counsel for the writ petitioner. Assailing the transfer order dated 23/9/2024. The petitioner has approved, whereby he has been transferred from the BBO Guwahati and posted at LGBO Patna. The petitioner has approved this court by filing the instant writ petition. Mr. Sharma has argued that the petitioner is facing some personal difficulties in as much as his wife is posted at Nagaon.
Yes.
Whose wife, who is a government servant,
Yes.
is presently posted at Nagaon. And the petitioner also has a minor child who is suffering from some serious health issues. Under the circumstances, the petitioner will face extreme difficulties if he is forced to join at Patna. Mr. Sharma has further argued that the reliever of the petitioner
Page 44.
also submits that the reliever of the petitioner, that is the respond number.
Because against him there is no grievance as such. Because he also doesn't want to come to Assam,
Has
Northeast.
been allowed to continue in New Delhi.
Yes.
And therefore there is no extreme urgency in the matter. Mr. Gupta, Mr. H. Gupta, Learned CGC, on the other hand, submits that the petitioner was transferred and posted at Guwahati in the year 2019, and therefore the transfer order has been issued in a routine manner so as to carry out internal adjustment in the department. Full stop. After perusal of the transfer order dated 23/9/2024, I find that that is a series transfer order by means of which transfer and posting of as many as 7 officers serving under the respondent number 1, serving under the respondent number 3. No. What is the authority? Serving under the Brahmaputra Basin Organization.
Government of India, my lord.
So they are under the respondent number 1.
Yes.
Has been affected. Full stop. There is nothing to show that the transfer of the petitioner from BBO Guwahati to LGBO Patna was impermissible either under the rules or the departmental guidelines. Full stop. Under the circumstances, transfer being an incident of service, the scope of interference by the court in such matters is extremely limited. However, since the petitioner has expressed difficulty in joining at Patna due to his personal reasons, and the earlier representation dated 16/2/2024 submitted by the petitioner before the respondent number 2 has not been considered till today. Hence, this petition is disposed of by granting 7 days time to the petitioner from today to submit a fresh representation before the respondent number 1, ventilating his grievance in the matter. If such a representation is filed, the same be considered in accordance with law, an appropriate order be passed therein. Full stop. Till such time, the representation is disposed of, no coercive action be initiated against the petitioner, subject to the condition that the petitioner submits the representation by enclosing a certified copy of this order within a period of 7 days from today. Writ petition stands disposed of.
Item 43.
Wait, please. My lord, rules, my lord, if your lordship looks into rule at page 60, relevant rules. They are to call 4 times the, my lord, officials for the purpose of consideration
You are
of promotion.
allowed to sit in the
Yes.
department. Why do you say so?
The 235 seats are there and they have called at page 70, my lord.
What is the
The
instruction?
examination will be held in 2 phases. This is the phase 1, 411 candidates, and the second phase will shortly declare the dates, lordship. This is the instruction.
So they will be called in.
He'll be called. Yes, lordship. Everybody names in a gradation list, all of
Because
them will be called.
235 posts are there.
Definitely he'll be called.
But if it is 4 times, my lord, I come in.
They are saying you will
Yes,
be
yes,
called.
they'll be
Lordship
called.
may record. That is good.
Had Mr. B.D. Das, Lanet Senior Counsel, appearing for the petitioner who submits that
When will be called?
his clients have been excluded from appearing in the departmental examination scheduled to be held on 6/10/2024 for filling up the posts of
The class 2 post, my lord.
AAI Class 2 posts under the Department of Agriculture. Full stop. Agriculture, although they come within the zone of consideration. Ms. R. Bora, Lanet Standing Council, Agriculture Department, Assam, submits on written instruction dated 1/10/2024 that the departmental examination will be held in 2 phases, and every candidate whose name is included in the gradation list, including the present lead petitioners, shall be given an opportunity to participate in the departmental examination. Full stop. From the submission of Ms. Bora, it is clear that the petitioners will be allowed to participate in the second phase of the departmental examination, the date of which is to be notified soon, notified soon, full stop. If that be so, there is no good ground for this court to entertain the writ petition at this stage.
On that ground, my lord, I am not
As
pressing
such,
it. Your lordship will give me liberty in future if they do
On the
something.
request of Mr. Das, this writ petition stands disposed of on withdrawal with liberty to file afresh
If
as
so
and when a
required.
proper cause of action arises.
Item 44.
May I please, your lordship? My lord, I have challenged the transfer order on the ground that it is a punitive transfer. Your lordship, kindly see annexure 2, page 12.
Annexure?
2, page 12.
You have been transferred from where?
From
Lambding to Ghaziabad.
So it is a transferable service.
Yes, Your Lordship, kindly see the second part, second paragraph. Further, it is
And the petitioner belongs to which place?
Lambning.
Is a
His
permanent.
only the correspondent address is given. Permanent residence
Permanent
address is
Rajasthan.
Let him go and join.
Your Lordship, kindly see the language. Your Lordship, kindly see the language.
Nothing.
It is clear that it is a punitive transfer.
All right, heard Mr. I. Rafiq, learned counsel for the petitioner. This writ petition is.
Only 1 year ago, my lord, I have joined.
Order dated 19,
Only 1 year ago, I have joined. My lord. And
19/9/2024, issued by the. Who is
respondent
it?
number 4, 3.
3.
Respondent number 3, transferring the petitioner from Lambding and posting him at Ghaziabad in the same capacity. Mr. Rafiq submits that the impugned transfer order is punitive in nature. Full stop. However, it is not the case of the petitioner that his service is not transferable. Full stop. Ms. B. Sharma, Lanet CGC, appearing for the respondents, has opposed any interim order in this case by submitting that this order is not a punitive order. So, upper line, Mr. Rafiq submits that the impugned transfer order is punitive in nature.
And no ground is also, personal ground is also
from the language, it seems similar.
stated in the petition.
Ms. B. Sharma has, however, refuted the contention that it is a punitive order by submitting that no such ground has been given in the impugned order of transfer. In view of the above, issue notice of motion returnable in 8 weeks. Since Ms. Sharma has accepted notice on behalf of all the respondents, no formal notice is required to be signed in this case. Extra copies of the writ petition be furnished to the learned CGC. Heard on the prayer of interim relief, the said prayer is rejected. The petitioner to join in the place of posting, in the new place of posting as per the order dated 19/9/2024. However, subject to his joining, the validity of the transfer order shall be examined at the stage of hearing of the writ petition. Upon perusal of the records, validity of the upon perusal of the records.
The petitioner is an officer of the Assam Police Services, Your Lordship. In November of 2023, a show cause was issued to him saying that his entry into the service was illegal because his marks in the examination.
What is the grievance here?
Presently, Your Lordship, on 17th of September, a charge sheet has been submitted in the special case before the special judge, Your Lordship. So I am praying for at least my immediate concern is that the disciplinary proceedings should be kept in abeyance, Your Lordship, till
What is the stage of disciplinary proceeding?
I filed a preliminary written statement, Your Lordship, because certain documents have not yet been provided to me.
Right.
And
You already filed.
a preliminary statement because certain statements have not yet been provided to me.
When is the next date?
In the special, before the special judge, it's on.
No, in the disciplinary.
There, what has happened, Your Lordship, is the inquiry officer has returned the file, Your Lordship, because he has been transferred to some other.
Let them obtain instruction both on the main and interim.
Very well.
We'll fix it
Very well.
on 20th October.
Very well.
Heard Mr. K.P. Pathak, learned counsel for the petitioner, peruse the amendments made in the writ petition. Issue notice returnable on 28/10/2024. Mr. C.S. Hazarika, learned G. Assam, has appeared and accepted notice on behalf of all the respondents. As such, no formal notice is required to be sent in this case. Since the extra copy will be furnished to the learned departmental counsel, since the petitioner is praying for a order of stay of the departmental proceeding in the ground that on the same set of facts, a criminal proceeding is pending against him wherein charge sheet has been submitted. The learned government advocate Assam to obtain instruction and appraise this court on the next date fixed, the stage of the departmental proceeding and the next date fixed therein. Full stop. The prayer for interim order will be considered on the return.
19 motion matters, item 6.
Second call, none appears for the petitioner even in the second call during the course of the day. This matter stands adjourned based after puja vacation.
Appear for 1 to 5. 1 to 5.
Mr. D. Boral and G. Asam is present on behalf of respondent numbers 1 to 5.
Item 8.
May I please, my lord? My lord, if lordship says page 17, my lord, the petitioner who is serving in the grave, he has suffered a disability. Lordship would find at serial number 18. The disability is aggravated by the stress and strain of the force. Now, my lord, their transfer policy, which lordship should find at page 42.
What is the order of transfer?
My lord, order of transfer is at page 44. My name is at page 45. The grievance is very limited, my lord. The transfer policy says that if I am a person with low medical category, I should have some medical facilities available at my place of posting. That lordship would find it page 42. Page 42, serial number 32. While issuing the posting orders of personnel of low medical category, the recommendations of medical authority available in the service documents are taken into consideration and personnel are posted to a place where requisite medical facilities are available. Now, I make a representation, which lordship finds at page 47, saying that there is no medical facility for degenerative disc disorders at the place I am being posted. Reconsider my place of posting.
Well, where is it? Where?
My lord, lordship will find at page 47, para 5. And para 6, I said, I'm ready to go anywhere else. I just need the facility. They reject it at page 49, lordship will find.
Your name is at
Serial number, page 45, serial K.
you have been transferred from?
From my lord, Guwahati to right now at Inkyong in Arunachal Pradesh. I'm sorry, my lord, not Inkyong, it is 761 BRTF Brahmang, Inkyong, somewhere near Inkyong in Arunachal Pradesh. That lordship will find at the second column. From RLC, that is Eastern
Your name
Sector.
is Naval Kishore Kaushik.
Naval Kishore, my
At page 45, it's K.
K. Second column is the place from where I'm being transferred to. Down, the next is ADG.
Yes, what is this?
Lordship, he is office superintendent. He is the Barababu of the office, Lordship. He has not need not go to the field and do work. He will be simply at the office, Lordship.
He wants the facility.
And is the district headquarter. Yongkyong is the district headquarter of Upper Siang, Lordship.
For that, Lordship would have page 50 for everyone.
Alternately, he can go to the Pasighat, Lordship.
Listen. See the page 42.
Lordship.
This is your own rules.
It only says consider. That we have considered.
No. Medical facilities has to be available, not going to the field or
That
not
is,
going.
he have stated that he obtained through an RTI that there is no neurosurgeon at the district, Lordship.
And the orthopedic also. Nobody is available, Lordship. Will find at page 50.
Alternatively, he can go to the Pasighat, only 3 hours journey, Lordship.
Pasighat is okay.
That is 3 hours journey, my lord. Pasighat, if they post me at Pasighat, I'll be there.
Right.
No difficulty.
We'll dispose it. Taking
Pasighat is okay.
Pasighat.
Let him file a representation, consider if that post has to be available there.
It is available and my representation, which is at page
That
53,
availability
goes unanswered.
For that availability, have to take instruction, Lordship.
Page 53, page
Tell us tomorrow, then we'll dispose it. Tomorrow. Heard Mr. R. Majumdar and counsel for the petitioner. Also heard Mr. B. Chakravarti, learned CGC appearing for the respondent who seeks posting of this matter again tomorrow, that is give the date so as to obtain instruction if the petitioner can be posted at Pasighat instead of, what is this?
Inkyong. This is
Inkyong.
761 BRTF, my lord. Lordship would say 761 BRTF.
Inkyong,
YEING KONG.
KIONG. Inkyong, bracket AP. In view of non-availability of medical facilities on account of this
Low medical category.
low medical category condition. List accordingly.
Obliged.
If it can be done, we'll pass an order. That's all.
Obliged.
Because Mr. Chakravarti said this is about availability of medical facility. These matters will take time. Then again,
Otherwise, he's not to run in the field and all.
no, we don't.
He's
need
only
to-
office superintendent.
Field is not the point. Medical facility is the point. So then we'll have to issue notice and status quo and all these things, which we don't want to do.
Obliged.
Yes, what is the instruction?
मैं कोई पहले में हुआ ना
So it says nothing about the review.
Lordship-
We'll
Lordship
set
can-
it aside and allow the.
Lordship can dispose of in light of this matter that
He has heard Mr. Ayat Saikal, learned counsel appearing for the writ petitioner, also heard Mr. J. Hendrick, learned standing counsel, Revenue and DM Department Assam appearing for the respondents. Stuff. The case of the petitioner in a nutshell is that while working as, he was working as
is a deputy registrar, deputy registrar, deputy registrar Nagaman.
deputy
Register.
deputy registrar Nagaon in the establishment of deputy commission district.
No, IGR, Inspector General of
In
Registration.
the establishment of Inspector General of Registration, by order dated 30/12/2023, he was placed under suspension.
21 to 2024, madam. Just a deemed suspension.
The petitioner was arrested on 30/12/2023 in connection with, what is the case number?
In connection with Melody.
Bitanagar PS case number 309 public 2023. Registered under in page 5, you will get it, section 120B, etc., etc.
Page 26 is the internal order.
In view of his arrest by invoking the provisions of Rule 6(2) bracket close of the Assam Service bracket Discipline and Appeal bracket close rules, 1964. The petitioner was placed under suspension with effect from 30/12/2023. By order dated 21/2/2024, passed in PA number 564 of 2024, the petitioner was released on bail by this court. Full stop. Immediately after his release on bail, the petitioner had communicated the order dated, is it 21 or 29?
Order dated 29.
29 to 2024. 29, you have done overwriting in the.
29, madam.
29
Wrongly
to
typed.
2024. To the Principal Secretary to the Government of Assam, Revenue and DM Department, by forwarding letter dated 11/3/2024 with a prayer to reinstate him back in service. The grievance of the petitioner is that despite receipt of the communication dated 11/3, despite his release on bail, and also receipt of the communication dated 11/3/2024, the respondents have neither reinstated him back in service, nor has the order of suspension been reviewed till date. Notwithstanding this, despite this, the petitioner has been continued in suspension. Full stop. Taking note of the grievance expressed by the petitioner's counsel, Mr. J. Hendik, Learned Standing Council, Revenue Department, Assam, was granted time to obtain instruction in the matter. So today, when the writ petition is called up, Mr. Hendik has produced a copy of the communication dated 3/10/2024, issued by the Joint Secretary to the Government of Assam, Revenue and DM bracket registration bracket close department, perusal of which goes to show that efforts are on to initiate departmental proceeding against the petitioner by serving him with a memorandum of charge. However, this written instruction, however, in the written instruction dated 3/10/2024, there is not even a whisper as to whether the order of suspension of the petitioner has been reviewed, and if so, whether the same has been extended by any order passed in the departmental file. Full stop. In which is the judgment?
Lordship, in the last para, Lordship, page, internet page 6. Lord.
In the case of Ramanath Burman versus State of Assam and others, third bracket WPC number 338/2022. This court, while dealing with a similar writ petition, had observed that in view of the law laid down in the case of Ajay Kumar Chaudhary versus
Union of India.
Union of India and another, reported in 2015 bracket close 7 SSC 291, Rekubuddin Ahmed versus State of Assam and others, third bracket WPC number 3218/2019, as well as in the case of Atfur Rahman, ATFUR Rahman versus the State of Assam, third bracket WPC number 6842/2018. Atfur is not required, no? Atfur part is not required. An order of suspension would automatically lapse on the expiry of 90 days unless the same is reviewed and extended by a subsequent order upon initiation of departmental proceeding. It is the admitted position of fact that neither any memorandum of charge was served upon the petitioner, nor has the order of suspension been reviewed after the expiry of 90 days. If that be so, it is apparent that the suspension order of suspension dated
21/2/2024.
21/2/2024 has automatically lapsed after the expiry of 90 days with effect therefore. Under the circumstances, this court is left with no alternative but to make a declaration to that effect. Consequently, it is provided that within 7 days from today, the respondents shall pass appropriate orders for reinstatement of the petitioner. Full stop. It is, however, made clear that notwithstanding this order passed by the court, it will be open for the petitioner to initiate and continue with departmental proceeding, if any, against the petitioner by following the due process of law, and to pass any other order which may be permissible as per the provisions of law. Repetition stands disposed of.
All right.
Any other order in respect thereof, which may be permissible.
David is order infringement of Article 13.
May please, your lordship. Lordship, despite there is an order of now this honorable court, they have now filed lordship another additional affidavit. Lordship, the copy has been served to me. I don't know lordship whether it is on record or not, but I have not on record.
After vacation pass.
Fixing a date, lordship.
Yes. On the request of Mr. J. Kalita, Learned Counsel for the applicant, let this matter be listed again on 25th of October 2024 by tagging the additional affidavit filed by the applicant with the.
No, not lordship, it's an, I. They have filed this.
Affidavit filed by the respondent in the IA. Mr. R. Botakur is present on, I. Botakur is present on behalf of,
For, respondents,
on behalf of the respondents.
lodge.
Yeah, please, your lordship, affidavit is sent for waiting, lordship. Lordship, by tomorrow we will file our affidavit.
Tomorrow. Day after tomorrow, we'll find.
No, lordship.
Mr. M. Bhagavati, learned counsel is present for the petitioner. Ms. J. Bora, learned counsel appearing for the.
1, 2, 5 and 6.
Respondent numbers 1, 2, 5 and 6, prays for further 2 weeks time to file affidavit. Mr. D. Bora, learned G. Assam is present on behalf of respondent number 3. On the request of Ms. J. Bora, list this case again after 4 weeks. The affidavit on behalf of the departmental authority be brought on record in the meantime by serving advance copy of the petitioner's counsel. Any interim order?
Lordship, no, in fact, Lordship, the matter is pertaining to promotion from grade 4 to grade 3. Initially, they said that he belongs to DRDA and subsequently regularized, so he didn't cover the 7-year period. But now he have covered the 7-year period in government service also.
So we'll pass an order on the next day.
Lordship.
No further time for.
Lordship.
Much of it.
16 and 17.
May it please your lordship, this matter has been infractious, lordship.
Why order has been complied?
Lordship,
Why?
yes, lordship, we have been reinstated in service.
Sorry,
We have been reinstated in service, lordship.
Mr.
M. Alam, lordship.
Both the cases, both,
Lordship.
Mr. M. Alam, learned counsel appearing for the writ petitioner in both these petitions submit that his clients have been reinstated in service and therefore the writ petitions have become infractious. Miss
H. Barwa,
H. Borua, learned
BTC.
counsel is present on behalf of,
Mr. P. Nayak,
give me the response
BTC.
on behalf of the BTC authorities. In view of the submission made at the bar, the writ petitions stand disposed of as infractious. Any interim order?
No, lordship.
Both the writ petition. If there is an IA, it will be standing.
Item 18.
May it please your lordships, the matter relates to the regularization of the service of the petitioner, my lord. Your lordships,
Who is
the
the
petitioner
respondent?
has been working
Have they filed counter
since
affidavit?
1982, my lord.
But who is appearing for the respondents?
Your lordships, the government has taken a lots of time for filing affidavit, my lord. But till date, they have not filed any affidavit, my lord. A lots of
The
time was
petitioner's counsel
granted.
is present on the prayer of Ms. A. Neo, learned counsel,
Irrigation Department.
Neo, learned standing counsel, irrigation department. 3 weeks further time is granted as last opportunity for filing affidavit. If the affidavit is not filed within 3 weeks from today, the writ petition will be taken up.
Your lordships,
Disposable.
lots of time.
Already
Basis of materials already available on record.
read.
So, नाम तो दे दीजिए, as petitions.
Your lordship, the affidavit is sent for waiting. Lordship.
Miss, your miss,
Yunanda on behalf of J. Laskar.
Mr. J. Laskar and counsel is present for the petitioner. On the request of Miss,
NN Sharma, behalf of K. Gogoi for CGC.
on the request of Mr. K. Gogoi, learned CGC appearing in this case, who submits that affidavit has been sent for waiting. 3 weeks further time is granted for filing the counter affidavit. List the matter accordingly.
Item 20.
May please your lordship. Well, this is in respect of a disciplinary proceeding, your lordship, by order dated 13th of September. My lord, stay the one document, and this has been, my lord, fixed for consideration of interim prayer regarding stay of the, my lord, disciplinary proceeding. Now, since, my lord, the notice by which the petitioner was asked to be present personally before the DB that has been stayed, perhaps, my lord, the other part we can skip later for later on. And the order is.
Yes, do you have
until-
instructions?
Yes, Lord.
So what is your instruction? How could this notice be issued by respondent number 3? That's the question.
Lordship, in the first, in the second page, Lordship.
Somebody else has been appointed as inquiry officer?
Yes, inquiry officer, to appear before the inquiry officer, so as per that instruction, Lordship, it appears that on behalf of the inquiry officer.
Can't be done. Heard Mr. M.K. Chaudhary, learned counsel for the senior counsel for the petitioner. Also heard Mr. J.K. Goswami, learned additional senior government advocate Assam, who has produced a copy of the written instruction dated 23/9/2024. Full stop. A perusal of the same prima facie goes to show that the notice in question was issued to the petitioner by the respondent number 3 on behalf of the inquiry officer, namely Sri Vivek Raj Singh, bracket IPS. Mr. Goswami has however not been able to satisfy this court as to how some other officer can issue notice to appear before her on behalf of the inquiry officer under the extent Assam Service Discipline and Appeal Rules 1964. You show us how it can be done.
Lordship, he is the presenting officer, Lordship.
Who is the presenting officer?
The respondent, here, Lordship, is the respondent, Lordship. The Assistant Inspector General of Police, Lordship, is the presenting officer here.
So presenting officer, how can the presenting officer summon the delinquent to come and record it? Under which provision?
Lordship, then that is, Lordship, he,
Mr. It appears that Sri Vivek Raj Singh IPS has been appointed as the inquiring officer so as to inquire into the charges brought against the petitioner. However, the respondent number 3, who is the presenting officer, has issued the notice directing her to directing the petitioner to appear before him for recording her statement. Mr. Goswami could not, however, satisfy this court as to under which provision of the rules such a recourse could be initiated. First, considering the above and on the request of Mr. Goswami, 4 weeks further time is granted to the Departmental Council to address the court on this issue. Office to reach this case again on 30th of October 2000, no, 6th of November 2024. Interim order passed earlier to continue. How can, see, presenting officer will present the department's case. So how can he, then what is
on
the
behalf of inquiry officer, he can.
We'll quash it, but we'll make some stinging observations.
But Lordship, here there are two issues, Lordship. One, the letter which is issued, someone the someone which is issued by the presenting officer. Other one is for stay the proceeding, Lordship. On the regarding the second part, stay the proceeding, I am strict on that, Lordship. But here, Lordship, regarding the someone issued by the presenting officer,
Only that is stayed.
I have
Proceeding has not been stayed.
That was one of the, so far as the prayer for proceeding, stay of the proceeding is concerned, that was to be considered.
It is however made clear that this order shall not constitute any direction to stay the departmental proceedings.
My lord, that prayer I was, my lord, going to make.
That we are rejecting, that cannot be stayed.
My lord, on that, my lord, I'll make submissions, my lord. My lord, I'll rely on the decision of the Honorable Supreme Court, my lord.
How much time will you take, Mr.
No, my lord, only 2-3 minutes, my lord. Because in earlier cases also, my lord, your lordship and my lord, the other persons who have been, my lord, the petitioner has been my lord, implicated in a criminal case in a supplementary my lord, charge sheet on a file recently in a 2017 case. The other persons, my lord, who have also been analogously, my lord, incriminated, they have been given this same benefit, my lord. I'll place those orders also. Before that, your lordship may kindly come to this order, my lord. 2014 3 SCC 636. Tangent or paragraph 10, mine.
Then we'll consider the other interim relief on the next date.
Yes, mine.
Then you write,
Mine.
the prayer for stay of disciplinary proceeding as made by the petitioner also shall be considered on the next date fixed.
Mine.
You are
Right.
address report on that.
Lordship, may be allowed to submit an affidavit, Lordship,
Yes.
counter
The
to.
landed government advocate, some may in the meantime file affidavit, bring the stand of the department on that.
Unless.
For orders, I can print you.
That appears with the petitioner on call. Adjourn for 6, adjourn for 4 weeks.
I can print it free.
That's a contempt proceeding. After issuing notice, they have passed an order, complied.
Mr. H.K. Sharma, our counsel for the petitioner submits that the order of this court has been complied with and therefore this contempt will be closed. In view of the above submission made by the petitioner's counsel, the contempt case is closed.
May please this matters be taken up after the vacation matter. I need to file an affidavit. I have.
Mr. R. Majumdar and counsel for the petitioner seeks posting of this matter after the puja vacation, so as to enable him to file affidavit. Mr. K.K. Parasal, learned counsel is present on behalf of the respondent. We have already filed one. Respondents.
Obliged.
Lordship, service report is incomplete. Let me take fresh steps, Lordship.
Mr. B. Chakravarti.
Only the private respondent. That is copy number 1.
Leave to take fresh steps for service of notice upon the respondent number 2.
1. Copy number 1, Lordship. That was the writ petitioner.
Acha. OP means it's a respondent.
It's a review petition, Lordship.
So OP number
1, Lordship.
1. By registered post with
As well as usual process, Lordship.
as well as by usual process. Steps be taken.
It's been complied with, Lordship. Complied with.
Mr. R. Fukul, counsel for the petition submits that the order of this court has been complied with. This contempt case is therefore closed.
Complied.
Lordship, matter has not been complied with till today and similar matter pending before this court, Lordship. Contempt case number 777 of 2022. So matter may be tagged with that matter, Lordship.
In fact, my lord, that there is a direction to place it before the Marine Council. The matter was placed on Marine Council before on 28 March 2023. I will put up on affidavit. That will in place. And only he will get
Which is the connected contempt case?
Lordship, connected contempt cases, Lordship, contempt 777 of 2022, Lordship. In a similar matter, Lordship, in that case, on my learned friend has submitted that the mayor in council's Lordship order.
This case, Purvachari learned counsel for the petitioner submit that the order of this court has not yet been complied with. However, she makes a request to the court to post this matter after vacation along with contempt case C, bracket close, 777 of 2022. Mr. S. Bora, learned counsel is present for the respondent and please for some time file affidavit. Prayer allowed, let the matter be listed accordingly.
My lord, the compliance has come, my lord. The MSAP has been revised, my lord.
Mr. Pathak, B. Pathak, learned counsel for the petitioner submits that the order of the court has been complied with and therefore this writ petition be closed. Mr. S.S. Roy, learned counsel is present for the respondent. In view of the submission made at the bar, this contempt case stands closed.
Obliged.
My lord, against the order dated 22/9/2022, my lord, one order has been, I have received a copy of this order
That is
without any, my lord, affidavit. However, it appears that, my lord, it has been passed after it was given with 1 month time, but it is passed about 1.5 years, my lord.
But the
However,
order,
my lord,
order has been complied with.
complied with, but very late. Anyway, I want to be able to withdraw this contempt to file a fresh writ
All
petition.
right. Mr. R. Goswami, learned counsel for the petitioner submit that the order of this court has been complied with by issuing the
Order dated 21st of June 2024.
21/6/2024, but after a great delay,
Yes.
thus causing serious prejudice to the interest of this client, Mr. Goswami therefore seeks leave to assail the order dated 21/6/2024 on such count. Mr. A. Kalita, learned counsel, is present for the respondent.
1 and 3, Lordship.
1 and 3. In view of the submission made by Mr. Goswami, this contempt case stands closed by granting liberty as
Liberty. Obliged.
But I can 26, Lordship, is disposed of. Only the name may be reflected for respondent.
26, Mr. D. Clark appears for respond number. Respond number?
So,
Sole respondent.
so. Item 34.
None appears for the petitioner for list after vacation.
Lordship, we have complied the order and filed affidavit.
Order has been complied.
Yes, we have received.
Miss, your name, please?
Yeah, free.
Learned counsel for the petitioner is present.
M.
Plus,
Burman.
M. Burman, learned counsel for the respondent submits that the order of the court has been complied with. This said petition has been confirmed by Miss Afrin, learned counsel for the petitioner. In view of the above, this contempt case stands closed.
Obliged.
This is an I. The petitioner was aggrieved because the respondents had imposed the maintenance of around 14,000 on him to pay to his wife during the pendency of the marriage. It was not by court, it was by the respondents. We challenged it. Now, my lord, have placed a judgment before the respondents showing that the marriage has been dissolved on the ground of cruelty. That was in January 2024. They are yet deducting my salary, madam. Let him have his instructions immediately after the vacations, whether they are deducting and why. After the marriage is
Sir,
dissolved.
Mr. R. Majumdar, learned counsel for the applicant, peruse the statements in the IA. Mr. A.K. Datta, learned counsel for the respondents, prays for some time to obtain instruction and appraise this court as to whether deduction is still being made from the salary of the applicant, even after dissolution of the marriage on the ground of cruelty. As prayed for by Mr. Datta, 4 weeks' time is granted for obtaining instruction.
But could it be before the next date of salary? Otherwise, they deduct it again, my lord, on the next date of placement. Before the
Next day,
first of.
that's good, 4 weeks.
If it's on 30th also, my lord, I can.
Next time, Karke.
Petitioner may be directed. Petitioner may be directed to submit the resolution.
Done. That is done with them, my lord. I have got a document also
Submit
that it
an
has been
application.
forwarded to them by the commandant.
In the meantime, the applicant's counsel to furnish all requisite documents before the competent authority.
I'll do that. Obliged.
One matter.
Wait, please, Your Lordship.
Yes.
I beg to trouble your Lordship. I was here in the courtroom. It's my fault, absolutely my fault. Item number 34.
Yeah.
I assumed that my matter was 36. It's my fault, Your Lordship.
What has happened?
There is a contempt matter. It's a contempt matter. It's not been complied with as yet. I did not see anybody from the other side appearing. If my presence can be.
Mr. Sharma is present for the petitioner. None has appeared for the respondent. So as to give one more chance to the respondent. Respondent to comply with the court's order. This matter is directly posted again on 22nd of October 2000.
I'm grateful to know. I'm grateful. I think 4, no, but I think 4. What 36?
Matter may come up. Matter may come up on 22nd along with the affidavit filed today, my lord. And my
22nd.
friends may be recording. Most of this.
Supplementary is for admission, item 46.
The problem has been solved
Also.
because it's because of your lordship's order also. This is the relieving order. they have
I'll
passed.
keep.
So repeating can be closed.
Yes. Your lordship will kindly note down that all the formality has been done. And ultimately, that's the order which has been issued to us.
And all the formalities have been observed. After this only he has been released.
We'll close it then.
Yes, only your lordship will kindly note down
Yes.
that this already relieved, all formalities have been observed. This order has been passed, so that we can just produce it before the authority concerned, that order also.
Right. Mr. D. Das Lanet, Senior Counsel, assisted by Ms. Barua P. Barua, Learned Counsel for the petitioner, submits that pursuant to the order dated 30/9/2024 passed by this court, fixing the matter today. The authorities have issued order dated 3/10/2024, releasing the petitioner from service of the corporation with effect from 3/10/2024 bracket F stroke N bracket close after completion of all requisite formalities. As per the memorandum dated 3/10/2024, the petitioner would be paid all his dues upon receipt of no demand certificate from all concerned. As such, nothing further survives for adjudication in the writ petition. Mr. A. Chakravarti,
Lordship.
Learned Counsel, is present for the
Respondent numbers 2 to 7, Lordship, on behalf of Mr. B. Sharma.
and agrees to the said proposition made by the petitioner's counsel. In view of the above, by retaining a copy of the order dated 3/10/2024 with a record of this case, the writ petition stands closed.
I'm the free of this.
What about the IA? Is there an IA?
IAs are not required.
I is not required, it can be closed.
IA dispose of closed.
Lordship, I am appearing on behalf of Mr. B. Sharma, Lordship.
I'll write one name only.
Lordship, then.
We have business in
No,
law.
Lordship, he is in.
Whose name?
Lordship, he, my name maybe.
Your name. That's what I've done.
No, Lordship, he is indisposed. He has undergone the surgery yesterday. That.
I see.
That's all right.
that-
We'll record only one name.
What I found that only because of the intervention of the court's orders are being passed. Then your lordship expressed appeal also. I find all the intervention of the court's order passed. Otherwise, they will not pass the order. If I would not have approached the court, I would have been lingering this way, that way. This is things are happening. I did not want again to reopen, and I don't know why they are doing it. I don't know for what purpose they are doing it. And in fact, I would keep this particular matter open because of suppression of facts in a judicial proceeding. Absolutely, my lord, there is a suppression of the facts. And they said only because of, see, my lord, I have lose this job also, that job also.
Yeah, we know, but we'll see appropriate case. We'll
I
take
know,
up.
we also have seen, my lord.